Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona. And today, we're talking about Prince Andrew, Duke of York. Womp, womp, womp. He wanted a motion to dismiss to be granted by the judge, trying to get Virginia Roberts' civil lawsuit thrown out. And the judge said, that's not going to happen. Sorry. Wrote a 46-page order. This is Judge Kaplan out of New York. And this is regarding the 2009, I think it's New York, a 2009 settlement agreement between Epstein and Virginia Roberts. And Prince Andrew and Dershowitz wanted this settlement agreement to cover them, to immunize them from any civil claims brought forward by Virginia. And the judge said that's not going to happen. And so we're going to go through that order. It is 46 pages, but we're not going to read all of it. We're just going to pick out some of the highlights because there is some good stuff in there. Answers a lot of the same questions that we've been talking about here on this channel, on this show. Specifically, how the heck are these agreements so broad, so encompassing that they can cover basically everybody, anybody under the sun? And so the judge goes through that and says, you know, because we can read this in a light most favorable to Virginia Roberts, we're going to allow this case to go forward. And so Prince Andrew is going to be facing this lawsuit moving forward. So that's good news for a lot of people. So we are going to break that down. There's also a different section in this same order that is addressing the Dershowitz argument. The judge actually talked about this in the argument. Of course, Alan Dershowitz, kind of a co-defendant in a way, somebody who was also being sued by Virginia Roberts a long time ago, back in 2019, before she filed the lawsuit against Prince Andrew. And so he's making his own argument that that same settlement agreement should cover him. And so the judge addressed that as well in the Dershowitz Argument section of the order. And so we'll break that down. We also have a new story from Dershowitz. Apparently, the Times over in the UK is reporting that he was asking Donald Trump to pardon Ghislaine Maxwell, which is kind of one of those stories. I'm not real sure how far you can carry that, but it is out there. And so we'll talk about that. And then we're going to spend the last segment on the show today talking about juror number 50. This is the Ghislaine Maxwell juror who was on the jury panel making the decision, rendering a verdict. After the verdict came out, he went out on a bunch of the different media shows and was doing an interview and explained what happened. Turns out he's the victim of the type of abuse that was the subject of the Ghislaine Maxwell case. Well, could be a problem, especially if he didn't answer it appropriately on the jury questionnaire. Sounds like he may have missed that. So we're going to hear from him. He gave an interview to the Daily Mail. He's hired a lawyer. He's asked for a copy of his own questionnaire. So we're going to take a look at that. Juror number 50 is Scotty David. And so we've got a lot to get to. If you want to be a part of the program, the place to do that is over at watchingthewatchers.locals.com. Shout out to Niceties in the house. Tweak is over there. We've got Kincaid is chatting away. Chairman of the board says, hey, all, what's good? A lot of people chatting away. We've got Matt's mom's over there. Tweaks in the house. Okay, and so over on YouTube, chatting away over there as well. And so if you want to be a part of the show, there's a form over at watchingthewatchers.locals.com. Looks just like this. Get your question in. We'll be sure to get to them. We also have a links channel, a clips channel at a different location on YouTube, and so go check that out. All right, so without any further ado, let's get into the show, shall we? I'm just seeing everybody who's chatting over there. Prince Andrew, Duke of York, facing a bad ruling from a judge today. Him and his team, as defense attorneys, wanted this case dismissed. Prince Andrew being sued by Virginia Roberts Giuffre. And you can see here we've got two different case numbers. We've got a case emanating from 2019. This is from Alan Dershowitz. We've talked about him a lot. Below him is the case from 2021. This is from Prince Andrew. And you know this because both of them submitted this settlement agreement. They submitted motions about this settlement agreement and the general release. And they submitted these to the court, asking that the court dismiss the cases against them, dismiss the lawsuits that have been filed by Virginia Roberts over towards these two guys. Now they're saying, these two guys are saying that Virginia's settlement with Epstein covered them because there was a big blanket paragraph in here. This is a direct withdrawal from the actual settlement agreement, this sentence here says that any person or entity who could have been included as a potential defendant or, quote, other potential defendants are basically covered, right? They're part of this immune, part of the settlement agreement, and this general release. And so this existed between these two people. It did not exist. If you go through this document, it doesn't say anything about Prince Andrew, doesn't say anything about Alan Dershowitz, doesn't say anything about royalty or, anybody from the UK, none of that. But it does say this, other potential defendants. And so we've spent a lot of time on this channel being very critical about these types of agreements that we have seen strangely in the Epstein case. The 2007 non-prosecution agreement sort of resembled this. Said that any of Epstein's co-conspirators were immune from prosecution. Never seen anything like that. Something that gives basically a blank check to anybody who is under the wing of Epstein. It's kind of nuts. But they decided to prosecute Ghislaine Maxwell anyways. And so all of that's happening. We've got this settlement agreement. Prince Andrew is holding this up in front of the court and saying, Judge, it says other potential defendants in there. Guess what? Guess what I am? I'm another potential defendant. In fact, I'm a defendant right now in this case. Look. But this says that we're immune and we're covered. And I want you to dismiss this case against me. And the judge said no. Here's what that opinion looked like. It was electronically filed on January 12th. You can see this is in the 2021 case. This is the Prince Andrew case. Duke of York. This is the opinion from the court. It's in the case of Virginia Giuffre versus Prince Andrew. And this is the judge who wrote it. We've talked a little bit about him. Let's revisit this quickly. Judge Kaplan, he's a United States District Judge. Yeah, he's out of the Southern District of New York, where all this is taking place. Appointed by Bill Clinton, who allegedly was on that aircraft that was being flown by Epstein or his pilots. Appointed by Bill Clinton, 94, serving all the way up to 2011. Looks like in the SDNY. He's been there, basically. Oh, I wonder why they... Oh, he took senior status. That's when he took senior status. Okay. So he's been there since. He took senior status in 2011. So you can see where he's from, right? New York. Went to Harvard Law School. Smart guy. And he wrote a massive opinion on this thing. So here is just a snippet. This is the table of contents in this document. And I'm going to show you what we're not going to cover, and then we'll cover what we're going to cover. So you'll notice that there's a discussion section here. So we're going to go through the facts because these facts are good. We can fly through them pretty quickly, a lot of footnotes, and we'll be able to just kind of skip over the footnotes. Some of the meaty stuff we'll get to, but it talks about everything that we basically spent time talking about in the Ghislaine Maxwell trial. I mean, we basically lived most of this, so we'll be able to fly through it, and you're going to go, oh, yeah, I remember that. The Epstein scheme, we've got that. We've got the defendant's relationship with Epstein and Maxwell, so that's going to be Virginia Roberts. Then we have Epstein recruits Virginia. Then we have defendant's alleged abuse. We've got the Florida state prosecution and the non-prosecution agreement, which we talked about. We've got Giuffre's Florida suit, the federal case against Epstein, and then the 2009 agreement, right? 10 pages of facts. We'll get through it real quick. But then you see there's a big discussion section. And the discussion section is responding to all of the different arguments that were proffered forward by Prince Andrew and Alan Dershowitz, really. Largely the same arguments as it relates to some of the crux of the main argument, which is the other potential defendants section. So I know this is kind of in the weeds, but let me just show you what we're getting rid of here. So down here, Prince Andrew was saying that this case should be dismissed because they didn't know enough information. So we remember this argument. Here, the prince was saying what Virginia put in her original complaint. She says a battery and intentional infliction of emotional distress. Like she said in there that she was harmed and she's, disturbed and distressed by this thing because of this outrageous conduct, but that's not enough information. He says, she's filing a lawsuit against me. I need more than that in order to defend myself. And so I move to dismiss the case because she has facially, on the face of the document, failed to bring a sufficient complaint. And he says, no, that's not true. They're actually not entitled to a more definite statement. He says the defense attorneys here will get detail when the discovery starts. You have everything that you need right now. Okay, other stuff will come out when discovery starts. So section 4, not valid. This case is not going to be dismissed on that basis. We also have another attack on the constitutionality of this lawsuit, saying that they didn't file it under the New York Child Victims Act. And he says, nope, that's without merit. That is not going to be a basis for dismissing this. So I'm not going to count that one either. And then we see this big section here from about page 31 down to, what is this, 35? That's not that big. The complaint states legally sufficient claims. So this is rebutting the argument proffered forward by the defense, Prince Andrew, saying that these are insufficient claims. We talked about this, right? I think it was a 12b6 motion, right? They didn't say enough. This section is saying that Virginia Roberts, in her complaint, just didn't even come up with a problem. Like, she said all this stuff happened, but that's not enough to bring a lawsuit. And the judge said, yeah, it is. She says her complaint is, in fact, legally sufficient. It's good enough. She says the defendant's contention that the plaintiff was obliged to plead specific facts, not accurate, doesn't have to do that. It's not how the law works. And she says that the two claims, so you can see here this IIED, that's intentional infliction of emotional distress, and the battery claims are not duplicative. So Prince Andrew and his lawyers were saying it's kind of the same thing. You know, if you batter somebody, aren't they also going to have emotional distress, right? I know battery's not that, but like if you assault somebody, right? If you physically abuse somebody, aren't they also going to be emotionally distraught? Be distressed? Yeah, right? So it's kind of the same thing. And they're saying, well, you can't sue us with both of the same thing. That's ridiculous. And the judge says, no, they're different. Okay, they are different things. Battery is different than intentional infliction of emotional distress. And so you can see we can just get rid of, a huge chunk of this. But really, most of the conversation is about this section anyways, which is really the analysis of the 2009 agreement. Legal principles, we'll kind of fly through a lot of this, but this is the argument that this agreement protects the prince. This agreement protects Alan Dershowitz. And you can see if we break this down just a little bit further, we go through the legal principles, we have the actual analysis of the agreement. And so we're going to go through that, and then we're going to wrap up with the Dershowitz argument as the last part of this order analysis. Which means we've got a little bit of heavy lifting to do. We've got some reading of a court order. Let's get to it, shall we? Here you can see Judge Kaplan, Lewis Kaplan, District Judge, Senior, SDNY, says, Plaintiff Roberts brings this action. We already talked about it. Battery and intentional infliction of emotional distress. Why? We know the story. She says Epstein and others trafficked her to Prince Andrew, who then abused her. She was under the age of 18 at the time. He says, and this is the judge writing, defendant denies, Prince Andrew denies Roberts' allegations and attacks her credibility and her motives. He asserts that she was complicit in Epstein's activities. But this is a motion to dismiss Giuffre's complaint as legally insufficient, not to determine the truth or the falsity of the charges. So what he's saying here is this is not a trial. Okay, we're not on trial right now. All we're trying to determine right now is whether this case can move forward or go away at this stage. So remember, this is not a criminal case. This is a civil case. So it's a little bit different. It's a lot of bit different. But we're still saying, like, we're not at a jury trial yet. Okay, we're not where we're going to determine whether this actually happened, whether what Virginia Roberts said happened actually happened. We're just asking ourselves this question. It's really a legal question. Is what she is bringing into court right now enough just to continue the lawsuit? Like, has she brought enough? Is there a basis for this? And so the judge is being very clear about this. Now, I want to spend a little time on this because the judge does so, obviously spends a lot of time on this. And he's, I think, doing it so that he's crystal clear. I think he knows that the public is going to be reading this. There's a lot of attention on this case. I think if this had less public scrutiny, maybe he gets away with a 20-page order instead of a 40-page order, but he's being very clear on it. And he wants to make sure that we can understand how he's sort of assembling this puzzle. He says, and defendant relies mainly, although not exclusively, on a 2009 agreement that he says shields him from liability, which we're going to break down. He says that the fact that the defendant has brought the matter before the court on a motion to dismiss is very important, of central importance, he says, as is well known for lawyers, but not for perhaps for the lay public. So he's going to explain this, right, for the public. As is well known to lawyers, but maybe not non-lawyers, the defendant Prince Andrew, by making this motion, placed upon the court the unyielding duty to assume, for the purposes of this motion only, the truth of all plaintiff's allegations, and draw in which is Virginia Roberts, and draw in Virginia Roberts' favor all the inferences that reasonably may be drawn from those allegations. Okay, this is the same concept that we talk about here on the show. We say, let's take the argument and frame the argument in a light most favorable to the person who's making the argument. Let's give everybody the benefit of the doubt. Let's say, all right, Virginia, if everything that you're arguing today in court, if we're just not even going to try to rebut it, we're going to say it's 100% true. That's what we're going to be doing here, right? We're going to be sort of setting that standard. And he's explaining that. We're going to draw all inference in favor that reasonably may be drawn from those allegations. Okay, we're going to draw in her favor. We're considering it. Why? Because Prince Andrew is saying, I want this case dismissed. And so here's how this works, right? If Prince Andrew comes in, he says, I want this gone. And we take a look at all the facts of Virginia Roberts' claim, and we say, look, Virginia, I mean, even if we said, you're right, that's true, even if it's all true, you still don't have a claim. Because legally, it's just bad. It just doesn't, it may all be true, but it's just not a violation of any of the laws or any rules. If that's the case, that's a failure to state a claim. You might be mad. You might think that this all happened or whatever, but it's not enough. But because Prince Andrew is saying, I want this case gone, we're going to give the person who is the non-moving party all the benefits that we possibly can. Because if there is one way that we can interpret it, in this case, in Virginia's favor, we let it go forward. So he's explaining that very clearly. He says, in consequence, the law prohibits the court from considering at this stage the defendant's efforts to cast doubt on the truth of Giuffre's allegations, even though his efforts would be permissible at trial. The law prohibits the courts from considering his efforts to undermine Roberts' credibility because he's moving to dismiss. So we want to keep this in a light most favorable to Virginia. In a similar vein, and for similar reasons, writes Kaplan, it is not open to the court now to decide, as a matter of fact, just what the parties to the release in 2009 actually meant. He says, I can't really know. It's not open for us to decide, as a matter of fact, what Virginia and Jeffrey Epstein, what they meant when they signed this document. But he does say, as we're going to explain below, the court's job at this juncture is simply to determine whether there are two or more reasonable interpretations of that document. We're going to look at the settlement agreement. If there are two or more reasonable interpretations, then what happens? He says, if there are, the determination of the, quote, right or the controlling interpretation must await further proceedings. Okay, because here's how that works. If Prince Andrew says that he's immune, and we look at this case in a light most favorable to Virginia, and there's nothing under that lens that would give her a claim to pierce that veil, then we have to dismiss the case. But if we look at this settlement agreement and we say, look, it's actually pretty reasonable in a light most favorable to Virginia that maybe she does in fact pierce that veil that Andrew is wearing, then this can go forward. Because we don't know what the facts are going to say, and we know that the realm of possibilities includes a potential Virginia Roberts victory. So we're going to allow it to go forward. And so the judge says, well, we got to determine that right now. So again, we're not determining what actually happened. Did Prince Andrew really do what the allegations say with Virginia? We don't know yet. But we're not asking ourselves that question. We're just saying, if he did, if we look at this all in a light most favorable to Virginia, will it continue? Here's what the judge says. Let's go through the facts. He says, except as otherwise noted, the facts are drawn from Giuffre's complaint. It bears repeating that its allegations are deemed true only for the purposes of this motion. Whatever a trier of fact might determine at trial, right? So something might change later at trial, but we're going to look at it in Virginia's benefit. He says, let's talk about Epstein's scheme. He says, Roberts' allegations arise principally from the scheme that was orchestrated with Epstein. In her complaint, she says Epstein was involved with more than 30 individuals in concert with paid employees. It says notably, Ghislaine Maxwell, who was recently convicted in this district of similar charges in connection with the Epstein events, Epstein and others lured vulnerable girls into a scheme for his powerful and wealthy friends, for his own gratification and for that of some of his powerful and wealthy friends. And he footnotes that. Yeah, but nobody's being prosecuted, are they? Huh, well, that's weird, Judge. Yeah. Bill Clinton, the guy who appointed you, was on the airplane. They looking into him at all? Yeah, so defendant's relationship with Epstein and Maxwell continues. So again, according to Giuffre's complaint, Judge Kaplan writes, the defendant first met Epstein in 1999, former close friend Ghislaine Maxwell. And we learned about that during the trial. Over the next several years, defendant traveled with Epstein and Maxwell. So this is talking about Prince Andrew. Andrew traveled on the airplane. He was a guest at Epstein's numerous homes, including the private island at the Virginia Islands, Little St. James, went to Palm Beach, went to New York City. They were palling around all over the place. This guy was being treated like royalty. Epstein and Maxwell were guests at the defendant's 40th birthday in the year 2000, Y2K, as well as the birthday party that the defendant threw for Maxwell in Sandringham in the UK in the same year. In 2006, then, 1 month after Florida prosecutors charged Epstein with crimes, defendant invited Epstein to the 18th birthday party of one of defendant's daughters. The defendant invited Epstein. Prince Andrew invited Epstein to the 18th birthday party of one of Prince Andrew's daughters. Is that registering here? Yeah. So in the year 2000, you've got Prince Andrew flying all over the place. Little St. James, New York, Palm Beach, hanging around with the Maxwells and the Epsteins. And then the defendant, Prince Andrew, invited Epstein to the birthday party of his daughter, who just turned 18. Okay, just making sure I read that right. Yeah, it's all there. As recently as 2010, and therefore after Epstein had done jail time, after also, oh my gosh, this just gets worse and worse. After 1 month after they charged him with procuring a minor. Okay, so it just gets worse. So I forgot about that. So not only did the prince invite Epstein to his daughter's 18th birthday, but the birthday party was 1 month after he got charged with crimes for things involving minors. My goodness. As recently as 2010, and therefore after Epstein had done jail time in connection with the charges, Prince Andrew was photographed with Epstein, and he stayed at Epstein's New York mansion. Carries on, says Kaplan writes, Epstein then recruits the plaintiff. Maxwell recruited Giuffre into Epstein's activities in the year 2000. When she was 16 years old, she was employed over at the Mar-a-Lago Beach Club in Palm Beach. Like others there, plaintiff initially was recruited to, quote, provide massages and therefore after to engage in a variety of acts for Epstein. You can see in the massage table, this one was pulled out of, I think that was from Palm Beach County. That came out of the Maxwell trial. From 2000 through 2002, plaintiff traveled frequently with Epstein, both within the United States and internationally, on his private plane. So Prince Andrew was on the plane. Plaintiff was on the plane. Plaintiff is Virginia Roberts. She's on the plane. In addition to being on call for Epstein for certain services, plaintiff on other occasions was lent out to others, including, she says, the defendant. Okay, now all of these quotes are coming from Virginia Roberts' documents, right, from her complaint. This is where she's making all of these allegations. And so he's saying, we're going to take these allegations and we're just going to look at them in a light most favorable to her. So she said here that she was lent out. Okay, check that one. Mar-a-Lago, does it have jurisdiction? Okay, got that one. So we'll do that jurisdiction. We've got this over here. A variety of certain acts, got that one, right? So that's a battery there. Would this be intentional infliction to be lent out to other people? Yeah, probably. So, okay. So we're going to look at all of that in a light most favorable. And then he goes on and talks about the actual abuse. We see the photograph, the infamous photograph now. Judge Kaplan writes, the complaint from Roberts alleges that the court, for the present purposes, is obliged to accept that Prince Andrew did, in fact, abuse Giuffre when she was under the age of 18. Okay? We have to accept it just for the purposes of this motion. On one occasion, Andrew allegedly forced her to sleep with her against her will at the home in London. Virginia Roberts also says the complaint includes a reproduction of a now widely published photograph, which you can see over here on the right. Plaintiff says was taken prior to the event, prior to the actual activity. On another occasion, defendant allegedly, so Prince Andrew allegedly abused Giuffre during a visit to the private island, Little St. James. Giuffre alleges also that the prince abused her at Epstein's mansion. That was in New York. Says specifically, during that particular encounter, Maxwell's involved now, says, quote, plaintiff, a child, and another victim were forced to sit on Prince Andrew's lap while there was touching. During the visit to New York, according to the complaint, defendant forced Miss Giuffre to engage in other acts. Both were aware of her age at the time, and she was a coerced victim. So Kaplan is saying all of these allegations in the complaint, we have to look at them in a light most favorable to Virginia Roberts. We have to say that those are true. He carries on. He says, in each of these encounters, plaintiff alleges that Epstein, Maxwell, and the defendant compelled her to engage in these acts, either expressly or by implied threat. As a consequence, plaintiff feared injury to herself, and there were other repercussions. This is what caused her to have significant emotional and psychological distress and harm. So that's the IIED. That's the intentional infliction of emotional distress. When I was in law school, I had a professor, shout out Professor Salzman if you're out there, who taught me this statute well, because she used to say intentional infliction of emotional distress is outrageous conduct, and she would scream it, outrageous. She says if it's just outrageous, it's not good enough. That's not the standard. It has to be outrageous. I'm going to spare everybody's ears, but she would say it in class, and it drove the point home. Shout out. She says, Kaplan says, the Florida state prosecution and the federal non-prosecution agreement. So this is something we spent a lot of time talking about, something I still think is an appealable issue in the Ghislaine Maxwell case, might become moot. Thank you, juror number 50. But this is still something that is very important. He says at this point, it is helpful and appropriate to refer to facts not alleged in the complaint, but in the case where the court takes judicial notice. Says in July 2006, Florida state grand jury indicted Epstein in a state court, single count. As will appear, the charge remained pending until mid-2008. This was an excerpt from that non-prosecution agreement. Now, this was not in the judge's order, but since we've been talking a lot about this, I went and clipped it out for us. And here is what you can see here. It says, if Epstein successfully fulfills all the terms and the conditions of the agreement, the United States also agrees no criminal charges against any potential co-conspirators, including, right? So potential co-conspirators, doesn't that mirror the same language that we see here in the settlement agreement of other potential defendants? Yeah, any potential co-conspirators very much resembles all potential defendants, right? Same type of language. So they're putting in these gigantic blanket coverages, but this doesn't name Ghislaine Maxwell, which is strange. It does say Sarah Kellen's on this list, Adriana Ross is on this list, Leslie Groff's here, and Nadia Marcinkova is on this list, right? Co-conspirators, including but not limited to these four women. So why does that not include Ghislaine Maxwell? And, you know, I mean, goodness, maybe they would argue, Prince Andrew would argue that that covers him if they charged him. I think he could argue that. He's making the same argument in this case. So this goes on. The judge is saying they have something very similar in that non-prosecution agreement. Let's revisit that. He says, as previously noted, defendant's motion in this case relies heavily on the 2009 motion as well, the 2009 settlement agreement, which is the language here. So two things. We've got the 2007 settlement agreement. I'm sorry, the 2007 non-prosecution agreement between Epstein and the U.S. government that give blanket criminal immunity to basically everybody. And then we also have this settlement agreement specifically between Epstein and Giuffre that is now being used, as the judge talks about, by Prince Andrew to immunize him from civil claims. The judge writes, as previously noted, defendant's motion in this case relies on the 2009 agreement, specifically this paragraph. First and second parties further stipulate that this is in conformity with the non-prosecution agreement that we just talked about. He says, so therefore, the non-prosecution agreement may shed some light on the meaning of the 2009 agreement. Therefore, we also take judicial notice of the non-prosecution agreement, its addendum, and its affirmation. So he's sort of considering it, but not really. He's taking judicial notice of it, but he's saying it's not binding. We don't have to comport with that, but I am taking notice of it. We're incorporating it into the record. And he continues. He says, Epstein relied on Maxwell and others to identify and target these people. Schools, spas, trailer parks, and the street. Recruiters lured these girls. Once manipulated, they were then groomed. Okay, this is the same pattern that we saw from Dr. Lisa Rocchio. Identify, target, sort of, groom with, more benign massages and then turn those into sexualized massages. Once this had occurred, they would then further manipulate them, promises, threats, and surveillance. And he's referencing the complaint. At the height, Epstein's sexual abuse was transcontinental, used his private jets, flew people all over the place. New York City, we've got New Mexico, we've got U.S. Virgin Islands, and other places. In 2008, he pled guilty to a crime. So in considering all of this, says the judge, we need to ask ourselves this. Whether the only reasonable interpretation of this phrase could have been included as a defendant is the one advanced by the defendant, whether that would be inherently unreasonable to construe the phrase as referring only to persons who could have been sued. Okay, so here's what he's saying. It would be inherently unreasonable to limit that phrase to only to narrow it. So he's kind of making an argument for Prince Andrew right now. He's saying it would be silly if the non-prosecution agreement and this settlement agreement was really, really narrow. But it's also not really, really, really broad either. Okay, it's also, as we're going to see, it's also not something that just encompasses everything. Just like it doesn't encompass nothing. So he says, let's get down to this. What can we tease out here? The judge writes, in this case, everyone agrees that the phrase, quote, could have been included as a potential defendant. It must mean something, he says. I mean, it's in there. It says could have been included as a potential defendant. And so the judge is doing the old, I don't know what this means. So let's just play some games with this, shall we? Let's play some games. What do you think it means, Prince Andrew? What do you think it means, Virginia? Let's see. It's in there, so it's got to mean something. He says, no doubt that is so. It means something there. He says, nor is there much doubt that better drafting probably could have eliminated any uncertainty to the meaning. Meaning if these guys would have written a better settlement agreement, maybe we wouldn't be in this pickle here. But these knuckleheads screwed it up. He says, in fact, however, the meaning of the phrase is far from self-evident for a number of reasons. We don't really know what it means. All right, let's begin, he says. He says, well, we should probably start with the question of what was meant by could have been included as a potential defendant, as opposed to could have been included as a defendant. So we're just going to focus on this one word, right? Potential. He says, well, one might suppose that whether one was or could have been included as a defendant, not included as a potential defendant, is clear enough. Although even that seemingly simple supposition, as we'll see, is not accurate in the context of this case. But the concept of inclusion as a potential defendant is even less capable of definition. So do you see what he's saying here? Now listen, I know this is going to be very tedious. Okay, we've got a couple more slides of this. The judge is making a very important point here. He's saying this settlement agreement is garbage, is really what he's saying. And it's going to be tedious because he's being very tedious here. he's just showing us how poorly drafted this really is. And he's saying, okay, so listen, so we're just going to have to slog through it. I'm going to have to type out why this is so logically inconsistent. And so he's exploring it. All right. We got a problem with this sentence. Could have been included as a potential defendant. Well, what's the problem with this sentence? Potential. All right. So let's read it. If we keep the word potential in there, what might it mean? If we take the word potential out of there, what might that mean? And then he says, well, I mean, it doesn't really matter what you do. That word is still a problem either way you do it. It leaves ambiguity in this thing. So he says, all right, so now let's carry on. Kaplan writes, look, of course, we do not know what, if anything, went through the parties' minds back when they signed this. He says, hypothetically, we can imagine what someone in Epstein's position might have thought at the time that they signed this. Let's say, he says, well, Epstein, at least some of the goals of a person like Epstein, presumably, would have been to end the Florida case, get as much protection for himself as he could, prevent himself from being involved in similar litigation, okay, and do so for an acceptable price. So in other words, a possible concern might have been that Giuffre, having settled with Epstein, could have sued someone else who might in turn make a claim against Epstein. Based on that contention, Epstein should then bear or contribute to the consequences. So he's playing this out, right? He's saying, okay, listen, let's put ourselves in Epstein's shoes. Epstein doesn't want to get sued again, wants to pay the least amount of money as possible, wants to immunize himself from this person and any other individuals that this person might trigger off to go and sue him. What happens if she starts blabbing about this stuff? So the settlement agreement should also keep her under wraps, right? He's putting himself in Epstein's shoes and saying, how can I get the best thing out of this deal? Like buying a car. Now he says she's going to be doing the same thing, but in reverse. The goal of somebody in Miss Giuffre's position, hypothetically, well, that could have been something like getting as much money as possible for settling the case and keeping as much of her freedom to go after others as she could while keeping an acceptable sum of money, right? So now Virginia is balancing two other factors, saying, well, I kind of want to do the right thing and go after a bunch of people and expose all these people. Well, I also want to be compensated for the harm that I received. So if I say that I'm going to get that financial compensation, but I'm going to give up these freedoms to go and do these things, how do I balance these out? So the judge is saying, okay, so she might sign an agreement that balance those competing interests. He writes, limiting the release language to persons who could have been sued in a particular court on a particular claim could secure that freedom to a substantial degree. And so some of this is on point, some of it isn't. They're also making jurisdictional arguments, and so some of it is more related to that argument. But he goes back to the 2009 agreement. He says, listen, the logic of the situation then, he goes on for this for a lot longer. I kind of took out some of this out. But he says, after we've explored all of these ideas, the logic of the situation thus suggests that the parties of the 2009 agreement had competing goals. Epstein wanted her to shut up and pay as little as possible, and Virginia wanted to say as much as she could and get paid as much money as she could. And the muddled release language they agreed upon suggests they may have arrived at something of a middle ground. A release extending not as broadly as Epstein ideally may have wanted, and somewhat more broadly than would have been the best case outcome for Giuffre. Okay, they met in the middle. They compromised on this thing. Moreover, he says it would not be unreasonable to recognize, among other considerations, that the settlement amount may have been affected by the views of both parties concerning the terms of the release. Epstein might be willing to pay more if he gets more. If she's more silent, then he'll increase the bill. Epstein perhaps would not have been willing to pay a price demanded for the broadest possible release of other persons. Clear language, or short of that, clear language concerning the nexus between other potential defendants and claims in Florida, right? So now we're talking some more jurisdictional stuff. Kaplan continues. He says there are additional considerations supporting the reasonableness of the could have been included as a defendant language. He says, listen, if we in fact take a look at this thing in a light most favorable to Virginia Roberts, we can come to some conclusions. Number one, first things first, the Florida case was brought in federal court. He says that gives them jurisdiction over this thing. The complaint in Florida, he writes, specifically alleges that Epstein had committed a number of such violations, but it nowhere alleges that this defendant committed any. It's not clear that a claim in a Florida case. Okay, so they're talking more about jurisdictional stuff here. And then we get near the end of this order, and this is what the judge is ultimately writing. He says, listen, in the last analysis, it is not now the court's function to decide which party's view of the term could have been included as a potential defendant in the Florida case properly reflects the intent, okay? He's saying, here, we don't even need to decide what that phrase means. Could have been a potential defendant. It's really complicated. Prince Andrew says it includes him. Virginia says it doesn't include him. He says right now, it is not the function to decide what it means. Don't know what it means. But he says it is enough, though, to conclude that the meaning of this pivotal phrase in the contract is not by any means unambiguous and free of conflicting inferences. He says we can take that phrase and reasonable people can disagree about what that means. The parties, he says, have articulated at least two reasonable interpretations of that language. Therefore, the agreement is ambiguous. Accordingly, the determination of the meaning of the release language must await further proceedings. Okay, so the motion to dismiss now is denied. There's enough looking at this in a light most favorable to Virginia Roberts to let this thing keep going. And because it's ambiguous, we got to dig into this a little bit further. It's not enough. So Prince Andrew's not happy about that. We'll talk more about that as the case continues to unfold. I'm already hearing that his defense team is preparing for depositions and fighting those requests, and we'll see where this goes. Alan Dershowitz also came up in today's order. We can see here, Dershowitz was in the 2019 case. Virginia Roberts Giuffre sued him as well. Epstein entered into that settlement agreement with Virginia, and Alan is now trying to use that to shield him from liability. Alan Dershowitz, new story came out on January 9th. Now, this came over from the times.co.uk. It says that Alan Dershowitz asked Donald Trump to grant Ghislaine Maxwell a preemptive pardon. Oh, my goodness. Could that be true? Epstein's former lawyer lobbied Donald Trump to preemptively pardon Ghislaine Maxwell during the final days of his presidency. Alan Dershowitz, 83, former Harvard Law School professor, represented Epstein during the 90s and Trump during the first impeachment trial, since been accused of abuse by one of Epstein's underage persons, which he denies. So some new stuff, interesting things coming from him. Now, I'm not sure I believe most of those articles. I feel like after every presidency, there's always a whole slew of those articles. Everybody just says that. Like when Obama was leaving, everybody was like, oh, yeah, everybody asked Obama for a pardon of that multi-mass murderer. Did anybody ask for that? Was he considering it? I don't know. But it's one of those stories. But Alan Dershowitz comes up in this order. In fact, he has an entire section here. Says the Dershowitz Argument. So the judge says, all right, listen, finally, now I want you to see how sort of messy this is. Okay, because it's just this is like lawyering in like its worst. This is what lawyers do, right? Killing each other over this language. He says, all right, so finally, Prince Andrew argues the interpretation of other potential defendants clause is the only reasonable one on the basis of events alleged relating to Dershowitz. Dershowitz now is a retired lawyer, law professor. Giuffre suing him in another case. Andrew says that Giuffre dismissed her claims against Dershowitz when his release was raised to her as a potential defense. This, according to Andrew, proves that if Dershowitz had his case dismissed, that this could also be dismissed here. During oral argument, court questioned that argument based on its suggestion that Dershowitz was covered by the release and therefore one of the, quote, second parties. In other words, that he was covered by the release independent of whether he was an other potential defendant, okay? So that Alan is saying that he is in a different category. On further reflection and analysis, however, the suggestion that Mr. Dershowitz was covered because of the second parties was not necessarily correct, he says. A release has three elements. Somebody gives a release, one against whom the releaser gives up or surrenders something, and a description of what is being released. Here he goes through the document. He says specifically Section 2 says that claims released were claims that the first parties ever had or may have against Epstein and other potential defendants. It does not say that first parties released the second parties other than Epstein, and he goes on. It's a lot of language. And it's first parties, second parties, Epstein. You can see how messy it can get. But he says it doesn't really matter. What it actually means is not what we're even talking about. Regardless of what the ultimate definition was, he says, listen, the 2009 agreement cannot be said to demonstrate clearly and unambiguously that this document directly, primarily, or substantially intended to benefit Prince Andrew. Okay, you can't read it that way. The existence of the requisite intent to benefit him, right? This document is not for him or others comparable to him, is an issue of fact that could not be properly decided on this motion because it's ambiguous. This, independent of whether the release language applies, and so as a matter of law, this cannot rewrite the agreement. He says, for the foregoing reasons, the defendant's motion to dismiss the complaint is denied in all respects. Not even considering anything else, so ordered. Lewis Kaplan, January 11th, 2022. That's the judge out of the Southern District of New York. And so that sort of also applies to Alan Dershowitz. We'll see what happens with his case. And so that's Judge Kaplan. Motion to dismiss filed by Prince Andrew, denied. Cases moving forward. Virginia Giuffre, we'll see what the next court dates look like. I'm sure they're going to be preparing all sorts of discovery motions, and I'm sure the Prince's attorneys over there are scrambling. I know that we talked about many headlines here. After Ghislaine Maxwell got convicted, they were on high alert. They thought, we're next. We're doomed. Looking like this train may keep going down the tracks. And so we'll continue to follow along on that. Ghislaine Maxwell also has a big update. We have to take a look at the court docket because a lot more activity since the last time we looked. Recall that on January 5th, we had this very interesting new order in the Ghislaine Maxwell case. Problem with a juror. And so the judge came out and said, we're going to have to brief a lot of these issues. Apparently, juror number 50, this guy, Scotty David, flew through the questionnaire. And after the trial was over, he started to give some media interviews talking a lot about some unfortunate things that happened in his past and how that might have influenced the deliberations back during the jury deliberations. So the judge had to get this thing under control. They said, we want this briefed. Everybody look into this. And they appointed him a lawyer. But then he went and got his own lawyer. We're going to take a look at this document, this notice of appearance. We have this order, docket entry 573, where the Judge Allison Nathan is relieving the court-appointed attorney of any further obligations and just allowing this to go through his attorney. Then we also have a joint letter. Now, this is a joint letter as to sentencing, right? The scheduling document. Remember, Ghislaine Maxwell got convicted, 5 of 6 counts. We were waiting just for sentencing. She was going to go get a pre-sentence report. She was going to go and be interviewed. Tell me about your past there, Ghislaine. What do you think about underage people and so on, right? All these types of questions. And then they're going to draft a report, and they're going to send that over to the judge. The defense is going to make their recommendation. Government's going to make their recommendation. PSR is going to make their recommendation. Judge issues a ruling. You go to prison for X many years. This whole thing has gotten totally derailed because now we have juror number 50, who is potentially going to cause a new trial. And we have hints that other jurors are also very problematic, which may lead to more of a systemic problem, in which case, the defense is going to be arguing for a dismissal with prejudice, I'm going to guess. So here, let's take a look now. We've got another order as to Ghislaine Maxwell. Parties are ordered now to submit any redactions. And so let's take a look at what's going on here. We can see this was Scotty David. Scotty David is juror number 50. And he started giving interviews right after the conviction went out. And so the Daily Mail was the first one to get the interview with this guy. You can see up here in the top right, you've got John M. Mantell over there from the Daily Mail. And so they got the full video. I don't want to clip too much of it, but I've got about 2 minutes of it. This is where he's describing his opinion on Ghislaine Maxwell. And then we're going to see the moment he realizes that maybe there was a question on the jury questionnaire that may have been problematic. So this is juror number 50.
In not really knowing much, but now, after what all I've learned, she's just as guilty as Epstein. She's also...
One sec, let me get that audio up.
Monster, in not really knowing much, but now, after what all I've learned, she's just as guilty as Epstein. She's also... I don't want to call her a monster. A predator is the right word. She knew what was happening. She knew what Epstein was doing, and she allowed it to happen. She participated in getting these girls comfortable so that he could have his way with them. And to me, them returning repeatedly for the money has nothing to do with anything, because these girls were minors, and it doesn't matter what was incentivized to them. What matters is what happened to them.
I thought it was a very...
So he goes on. There's a full interview with him, and you can listen to the whole thing if you want. Seems like a nice guy. He's just, he's out there. He wants to make a statement. Everybody wants to make a statement after they're involved in these high-profile cases. Okay, so you can go and do that. You're entitled to your opinion, right? This is a civic duty. He just spent a lot of time out there slogging away through a trial that was like this, basically a show, sort of half-hearted prosecution. Okay, so he's entitled to make his opinion, make his position, all of that, right? Here's where he gets a question from this interviewer. Now, you're not going to be able to hear too much of the interviewer because the volume is very low on her end. But she's got a British accent. She's over at the Daily Mail and says, so you decided to share your story here, Scotty, and your story involved some about your background and some of the things, the activities that happened to you. I'm just surprised that you were able to share that. I mean, they didn't ask you about this on the juror questionnaire. Watch his body language.
So it took to day 3 for you to really reach that level of understanding with each other and then make true progress with the deliberations? Would that be a fair assessment?
Yes.
So you decided to share your story. Presumably that's something that you'd tick yes to in the questionnaire. It was something that people were aware of when you were selected as a juror.
No, they don't ask your sexual abuse history. They didn't ask it in the questionnaire.
I thought in the questionnaire there was a question that asked if you were a victim or if you were a friend or a relative of a victim. Pretty sure it was number 48.
Number 48 in the questionnaire.
I don't remember.
Somebody sent me the questionnaire today and there was a question.
Somebody sent me the questionnaire.
I mean, I guess, when did you fill in that questionnaire?
I definitely, on the first day of jury selection, I would have definitely marked yes, but I honestly don't remember that question.
You're not in the sand right now, too.
No. I mean, I know my face is red because I can feel the blood, but I honestly, that's why I answered it that way. I don't remember it being there, but I did answer, I definitely remember a family or relative or something, but being sexually abused. I was honest on all my questions.
Oh, yeah,
Oh, man, this poor guy. Oh, no. I mean, you can see it. He just, no, I didn't answer that question. I didn't see that. They didn't ask me about that. Yeah, it's in there. It's in there, brother. Whoa. All right. And so, well, Ben Furhard over at New York Post says, here are the questions that the jurors were asked. So they were asked multiple trials about their past experiences with abuse, and they were warned that their answers would be used to determine whether they could be impartial in the case. This is more than a 51-question document that hundreds of people filled out under the microscope this week after juror number 50 admitted he used his own past abuse to sway deliberations. Prior to being selected, Scotty and hundreds of others were asked to truthfully fill out the questionnaire that included these specific questions. Have you or a family member ever supported, lobby, petition, protest, worked in any other manner for or against laws about any of those things? Witnesses in this case may testify about abuse or assault. Would you have any difficulty addressing the credibility of a witness claiming SA just like you would have any other witness? Assessing the credibility of somebody claiming that, like you would have with any other witness. Have you or a friend or family member ever been the victim of harassment, abuse, or assault? That includes actual or attempted or other unwanted advance by anybody, family member, teacher, so on. Yikes. Yeah, that's a big question right there. Have you or a friend or family ever been accused of abuse or assault or any of those things? So probably not that one, but yeah, that's a pretty big one there. Pretty big one. In several press interviews this week, David claimed that he said he wasn't asked about his history and said that he, quote, flew through the questionnaire. Flew through it. Nope. Like the doctors, you know. Do you have any of these conditions? No. Healthy as can be, baby. Don't need to fill out those forms. So you can see what's happening. So, yeah, he's a little bit in a prickly position, isn't he? Let's see what the judge says. So he went and hired a lawyer right away. Says a notice of appearance had been filled out by retained counsel on behalf of juror number 50. Retained counsel has communicated to the court juror does not wish to have an attorney appointed. Accordingly, the court is not going to appoint counsel as indicated previously. And so we're going to see that he fires off a letter. Here's what it says. That lawyer filed this. Counsel for juror number 50 has submitted a motion to intervene, and he wants a copy of juror's completed questionnaire and voir dire. Wants to see what he wrote on that questionnaire. Wants to see what he put in there. The motion has been submitted via email. Allow the parties the opportunity to propose any redactions. Dang it! The parties are ordered to submit via email, and so they're going to go and redact the heck out of it. Parties shall respond to Juror 50's motion by January 20th, so some more court dates coming up. Upon further reflection, unless and until juror number 50 is permitted to intervene, he may have no standing to be heard on the question of whether an inquiry should be conducted. Okay, so is he even a party to this case now? Now the juror is going to be involved in this case. In other words, the defense and the prosecution, in this case, Ghislaine's case, have said, we want an inquiry. We want to go investigate this. We got to dig into it. Now that this juror is a party to this motion to intervene in the case through his attorney, does he get a say in that inquiry process? Because he's a part of the inquiry. This case is so messed up, man. Accordingly, the court withdraws the aspects of its prior order setting the J26 date by which counsel for juror 50 should file a submission on the issue of the appropriateness of the inquiry. So now this juror is going to say, you shouldn't do an inquiry. You shouldn't go, right? The juror is going to make his arguments that they shouldn't go into what happened in the deliberation room. Preserve the sanctity of the deliberation. He shouldn't have to talk about this. Maybe he changes his statement. Maybe his statement to the media was a little bit off and he sort of reverts this back. Well, I didn't actually say that I was I actually didn't say that. What I actually said was this. But you shouldn't be allowed to go in there anyways. Anyway, court will hear from the parties regarding the juror's pending motion. Depending on the resolution of that motion, the court will provide further guidance to counsel about any other permitted submissions. If further submission is permitted, the court will provide docketing at that time. And we're not done with the jurors. Daily Mail is reporting Maxwell's lawyers told the Daily Mail on Sunday that they believe they have found a third juror in her trial who lied about being abused. Number 3, a source from Maxwell's legal team says they feel confident a third juror lied on their jury application. There are also questions over a fourth juror, so this thing is up in the air, says Maxwell's lawyer. New York Times confirms that. Says in another potential complication, a second juror described in an interview with the New York Times having been abused as a child. Okay, not Scotty David, not juror number 50, another one. So if the jurors got on because there was some sort of a catastrophic governmental problem, some sort of an error that happened here, what are Maxwell's lawyer going to say? Violation of due process. This juror who requested anonymity said that they too had discussed the experience during deliberations and that the revelation had appeared to help shape the jury's discussions. Oh, so they all talked about it. Two jurors' disclosures could be problematic if they failed to note their experiences to the court during jury selection. All potential jurors, so look, two things. Either they didn't say it, right? It's not on there, in which case it was erroneous and she should get a new trial. Or they said, yeah, I was abused, and they let him on anyways, in which case she should get a new trial. All the potential jurors in the case were asked in a confidential questionnaire whether they or anyone else had been a victim. Multiple people. Now, the government's going to come out and say, well, look, we should just try this all over again. But the defense is going to say, you had your shot. You blew it. You just want to keep trying her until she gets convicted? That's not how this system works. All right. So now, since this is all messy, we have to get scheduling figured out for Ghislaine. She was supposed to be sentenced. The judge asked everybody for sentencing memos and memorandums and briefs on when this was all going to be taking place. They can't agree on it, though. Can you believe that? On January 10th, they submitted this joint memo. They say, Dear Judge Nathan, the parties here, both the prosecution and the defense, we submit this joint letter proposing a schedule for sentencing, and we've also got to talk about those perjury counts. This schedule is in addition to all of the other stuff that we got to deal with now. But those have been dealt with in a separate order. Says the government believes that the court should order the preparation of the pre-sentence. So we've got two positions, what the prosecutors want to do and what the defense wants to do. The government believes that the court should order preparation of the pre-sentence report and schedule a sentencing hearing 3 to 4 months from today. They're saying, we think she's guilty. She's already been convicted. The sentence is going to be upheld. We'll prepare all this stuff in 3 to 4 months. We'll come back. We'll sentence her then. This gives us enough time to prepare the report for sentencing and secure any post-trial motions. It says in the event that the defendant's motion, so if Ghislaine Maxwell's motions are denied, the government is prepared to dismiss the severed perjury counts at the time of sentencing. You're kidding me. The prosecutors are going to dismiss 2 perjury counts? Wow, that's really nice of them. Why are they going to do that? In light of the victim's significant interest in bringing closure to this matter and avoiding the trauma of testifying again. Okay, so they're going to go ahead. So Ghislaine now is going to, they're going to go ahead and dismiss those. If they're saying if her motions are not successful and she does in fact get sentenced, then we're going to go ahead and just get rid of those additional perjury counts. We don't need to get this thing, get into it again because it's going to cause a lot of trauma to everybody who testified. But they say if Maxwell's motions are granted, the government proposes that the parties be directed to promptly confer and then propose a schedule for further proceedings. So kind of what they're saying is if Ghislaine Maxwell is successful in her post-trial motions, if she gets a new trial or whatever, they are going to look at those perjury counts and they'll move forward with the perjury counts. If the case is, if she moves forward to sentencing, they're going to dump perjury. If she escapes these charges, they're going to keep the perjury charges. Now, this is what the government wants. The defense is proposing something differently. They say they request delay setting a schedule for sentencing because there is a compelling basis for the court to overturn this conviction and grant her a new trial. The parties are currently briefing the issue regarding juror number 50. The defense, therefore, objects to setting a schedule for sentencing until this motion is resolved. For the same reason, the defense intends to set forth in its moving papers the reasons why Ms. Maxwell should not be forced to expend resources to brief other post-trial motions until after the court decides this motion. Why should we talk about a motion for acquittal, a judgment of acquittal? Why should we talk about any of those other sentencing memos or any of those other things? Because Ghislaine gets a new trial, it's obvious, is what they're saying. Juror number 50 screwed this whole thing up. There's several other jurors that we're going to bring to your attention shortly. Therefore, we're not going to waste our time on any of those other issues. We object to sentencing. We object to going down that road. We're not going to end up there anyways until this issue is resolved. Furthermore, they say requiring Maxwell to participate in the preparation of a pre-sentence investigation report while she's waiting a decision for her motion on a new trial will adversely impact her Fifth Amendment rights. Because during that interview, they're going to ask her a bunch of questions. Ms. Maxwell, they say, is going to be forced into the position of not cooperating with the probation department's investigation because any statement she makes will be used against her at a retrial. Pre-sentence, you go in, you talk about probation. Typically it's tell me about what got you in this position, be open with me so we can help you. And then if she says those things, in order to demonstrate that she's open to rehabilitation so that they give her a lighter sentence, so that they recommend, they say, oh, Ghislaine Maxwell's very sorry and she's going to try to be a better person in here. She's going to have to sit there and say, I can't talk to you. Because if I say something, you're going to record that and use that again in a retrial. So she's sort of screwed both ways. If she opens her mouth and talks, maybe she gets a good recommendation from the probation department, but she wins later on the motion for a new trial, and they take her statements and use them against her at a motion for a new trial. So she can't do that. So she has to keep her mouth shut, which might ultimately lead her to having a more serious sentence. So they say here, for the same reasons, the defense agrees with the government that the scheduling of any proceedings related to the perjury counts should be deferred. So Ghislaine Maxwell is probably going to be, escaping those perjury charges in addition to the other charges. And so let's see what you have to say about this over from our friends at watchingthewatchers.locals.com. Got some questions in the house on this one. Monster One says, Rob, your last name sounds like a fancy chocolate company. Govea. I think it's like Godiva is the other one. I don't think there's any relationship. What is Godiva? So Govea is actually Portuguese. Godiva is, what is Godiva? Turkish. Godiva is, it's a Belgian chocolate maker jointly owned by a Turkish conglomerate. Oh. Yeah, Belgian. So no, not even close, but kind of. I mean, it sounds the same, but it's just not the same parts of the world. Tweak says, I absolutely agree that far-right... wait, that was from yesterday. What happened to that? Where did that one come from? All right, so back to the locals questions. That was from Monster One, Godiva. Sergeant Bob says, I do not buy into the Me Too mania, although I do support provable cases. It seems there is a factual basis for Virginia's claim. She was starstruck teen and princely fellow apparently took advantage of that. What a creep. You're right about that, Sergeant Bob. And, his interview was just really horrific. Thunder7 says, really appreciate you getting into the legal nitty-gritty, but I still don't understand the judge's decision. Virginia was a paid person over to Prince Andrew and he slept with her. Why are Epstein's crimes against minors being dragged into this case? Virginia was a willing participant, even recruited young teenage girls into the ring. Maybe she needs to be charged instead of this ridiculous lawsuit, which is all about her getting more money. So the reason why it's continuing is because the judge is looking at it in a light most favorable to her, right? He's saying, look, a motion to dismiss, the reason you have to think about it this way is like, it's the end of the case. Like, it's it. Like, there's nothing else to do. So it is a ultimate consequence. So in order to make sure that it's absolutely the right thing to do, you take a look at everything the other person is saying and you just say, we're going to say it's true. So we don't know whether or not. So remember, Thunder, we're still very early in this case. There may be a lot more that comes out later that would support a dismissal on a different basis, but not right now, right? It's still a very preliminary motion, and there's enough to continue it onto the next stage, but that doesn't mean that it actually goes all the way to a jury trial, right? Sergeant Bob says, if the case gets tossed because of the jurors, then Officer Chauvin's case should be tossed as well. As we have discussed before, I agree with you, Sergeant Bob. Totally agree with you on that. The parallel here being, in Maxwell's case, we've got juror number 50. Juror number 50 goes out. I was abused. I was incorrect on my juror form. And that's disqualifying. Chauvin's case, same thing. Brandon Mitchell, forget what juror number he was somebody on the juror form said that he didn't participate in any political protest that were related to the George Floyd death. Guess what? He was all over the place. Now, he doesn't have Maxwell's lawyers, does he? There's a difference there. Thunder 7 says Scotty David either lied to get onto the jury, is lying now, or Judge Nathan allowed him to sit on the jury even though he should have been rejected. We'll see. I mean, if he answered yes on that form, there's going to be an inquiry. How did that form get through? How did he get on there? And we'll be able to point to where that happened. Says, is it all a legal ploy to ensure Maxwell goes free on a mistrial and she keeps silent about the VIPs who really did the bad stuff? Yep, it's all done deliberately to keep all the important names out of this. Can't argue with that one there, Thunder 7. Feels very wanting for sure. Sergeant Bob says, if I were ever on a criminal case jury, when hell freezes over, I would never, ever go yappy to the media. Those that do are but attention individuals. I can understand that, Sergeant Bob. Feels like they, people who sort of elbow their way to get out there, to get onto a jury, it's kind of not who you want on there. Ghost Gunner says, wow, this dude likely just corrupted that verdict. What is the penalty for perjury in a federal court? It's not good. A guy like that with no criminal history, an honest mistake, I'm not sure that they would prosecute him for that. I really don't think that they would, because it was a mistake. But if there was something intentional there, they could. I don't think you can say that this verdict was done by a fair and impartial jury, and he's not the only one that's questionable. Yeah, the media is saying there's several others. 4. Up to 4. So that's a nice chunk of the whole panel. Ghost Gunner says, I feel bad for Judge Nathan. She probably can't wait to finally get her promotion. You think she started getting her bigger paychecks yet? I don't know, but she's probably packing up. She's got those cardboard boxes filled. She's like running out the door. And her clerk's like, judge. 1 second. Remember juror number 50, the bald white guy? Yeah. What about him? Well, gonna need you to stick around here a little bit, Judge. She's not happy about that. Hopefully she doesn't take it. Well, maybe, we'll see if she takes it out on Ghislaine Maxwell during sentencing. Monster 1 says, anyone want to bet these jurors work for Epstein? Get on the jury. Make sure a mistrial happened. I can't comment on that. Sergeant Bob says, as much as I despise Maxwell, her dream team is earning their billable hours. They certainly are. This is all part of the plan, right? This is what they were doing. Soon as they can just latch onto anything, they were going to do it. They're sort of engineering, mistakes. Chairman of the board says, I feel bad for that guy. When the reporter tells him about that question, he looks like a deer in headlights. I know. I feel for him too, Chairman. But also, how on earth do you miss a question? Especially that one question. If you're a potential jury member on the most high-profile cases in years. All that said, they have to give her a new trial, right? How can they call it justice if they don't? I'm with you, Chairman. I'm with you. Totally. Right? It's justice. I've said that from the beginning. I didn't want this ever to be a dog pile on Ghislaine Maxwell just because she's Ghislaine Maxwell. Right? We don't bend the rules of justice just because we don't like the defendant. It's not how this works. And it's insane that, that our justice system is like so dysfunctional that we're going to go through this whole thing again. At least we have a mind map, so that's good. Vientikis says, what if you get abused by your inner child? Does it cause problems with you being a juror, asking for a friend? That's a whole separate conversation there, Vientikis. I don't think that one counts, though. Leafy Bug says, hey, Rob, if the Daily Mail got an exclusive interview with the juror, I think it's highly likely that money changed hands to make it happen. There seems a clear incentive, or at the very least, a perception of an incentive for potential jurors to lie to get onto the juries of high-profile trials so they can benefit from post-trial publicity. We saw this after the Chauvin trial as well. Do you think there should be some kind of restriction on jurors directly profiting off their jury duty experience in specific trials? No, I don't think so. I mean, I don't typically I understand your point here. I don't like more regulations and bureaucracy. I don't know that it's a problem to the point that you need to regulate anything like that, but I do understand your concern, and I think it is a valid one, as we've seen it happen now several times. But I don't think that even if you limited people from, speak like, for example, like lawyers, we are regulated, right? We can't do certain things with post-trial publicity because it might impact our decision-making opinions or our approach to handling a case in direct, measurable ways. An example would be if you have a high-profile case, you might do high-profile, risky things. You might try, different strategies or tactics that are in the best interest of puffing up your media profile, but not in the best interest of representing your client. You might try something risky because it looks good, but doesn't serve your client's interest. So you got to be sort of cognizant of those things. Jurors are a little bit different, right? There's enough sort of randomness in there that if they get picked, you sort of rely on other people to balance them out. If you have an oddball sticking out, you rely on the other 11 people to sort of even things out. It's kind of the law of averages. So there are other protections there. And I'm not sure if you put a limit on people being able to speak freely to the media or like go on YouTube or something. Like what if this guy just wanted to go on YouTube? Would you want to prohibit him from doing that? I don't think so. I think you want to make sure that people can communicate about that. Like if he came out and said, maybe I don't want to talk to the Daily Mail in exchange for compensation, but what if he was like Drew Hernandez? Well, he wasn't a juror. He was a witness in the Kyle Rittenhouse case, but he has a YouTube channel, right? He testified and went on YouTube after that. So I think people should be able to talk openly about what's going on. I would like to see more accountability. Like if we could see what was going on in this trial a little bit further, maybe we'd be able to identify where some of these catastrophic problems are happening. I don't know. It's a good question, but I think you're onto something by saying that, the more politicized these trials get, the more problematic it really is for the justice system. If you got people elbowing their way on to get onto juries, that's not good because they're looking to convict people to make a political statement rather than doing justice. That's nonsense. Oh my gosh, Prince Andrew's here. His Royal Highness, the princiest of the princes, says, please read this in your best posh English accent. I can't do that. How do they speak over there? One did not do it. You little people have forgotten that one cannot sweat. Is that British? Is that English? Delete that from your computers, whatever the hell that was. That was Judge Sullivan. Delete that from your computers, everybody. Erase that. Realtor Patty says it came out number 50, works at one of the best places that Epstein gave money to. Came out, he works at one of the places that Epstein gave money to. Oh. Is that for real? Number 50? So I got to look more into this Scotty fella, apparently, but my goodness. Sergeant Bob says, comic relief. Miss Lucky causes me to make supper tonight. If I displease her, I will be punished. Is that an actionable case? P.S. Would your mom give me her meatloaf recipe? I got to ask her. I got to ask her about that. She's pretty protective of those family recipes there, Sergeant Bob. But I think I'm watching the chat. Has Rob ever been to England, or has he only seen it in the movies? He's the Queen's favorite son. That was bloody dodgy. Nope, butchered it. Well, I gave it a shot. So, Sergeant Bob, no, you have no cause of action against Miss Lucky. She's fully entitled to demand that you make supper for her. And if it is subpar, in fact, I think she actually has the claim against you. So make sure it is up to snuff, my friend. We also have Monster One. Says, if Maxwell gets a new trial, do you think she might try to negotiate a plea? She's got to know she's getting convicted again. Any sort of delusional thought of acquittal had to die. Does this give a reason to give up names for a deal? I'm not sure about that, Monster One. I'm not sure. I mean, look, the jurors were full of people who had actual history of abuse. And it still took them like 4 days. And then they started saying, well, look, I was abused and, 5 days. So maybe if you take all of those people out, 4 people who also have been abused, apparently, according to her lawyers, maybe the verdict doesn't go that way. Because a lot of people were saying, we don't find them credible. And then Scotty David and these jurors come out and they say, well, let me fill in the gaps for you. What if those people are not there the next time? 4 of them are gone. I don't think she's going to make a deal because I think she's going to walk somehow, some way, shape or form. I think she knows it and they know it and the government knows it. And I think they know the government knows it. So why would they make a deal? I mean, stuff like this keeps happening. 4 jurors. They're just telling Ghislaine, hang tight, dear. Hang tight. We're on it. Don't worry about it. All right, my friends, those were the questions over from watchingthewatchers.locals.com. And Ronnie Cole sent in a super chat earlier today. I'm playing around with this little thing here, so we'll see if that works. I got to fix it because it looks terrible. But I'm trying to get the super chats on the screen as well. But my friends, that is it for the show for the day. I want to thank you for being a part of the program. And we're going to welcome some new members tomorrow to our watchingthewatchers.locals.com community. We've got a monthly meetup coming up in January. It's not this weekend. It is the 22nd. Monthly meetup, watchingthewatchers.locals.com. Got to register and sign up for it, but it's going to be a lot of fun. Hope you join us on that because we've got a lot to talk about. And so that is it for me for the day, my friends. Everybody, thank you so much for being here, for participating in the program. Have a tremendous evening. Sleep very well. I'll see you right back here tomorrow. Bye-bye.